So self-defense can be a valid legal strategy depending on the charges. And usually you cannot be the instigator, which means you're not the person who initiated whatever crime or situation occurred. And you can only use force that is equal to rebut and defend yourself, but nothing beyond that. So for example, if someone is coming at you and hitting you with their fists, unless your life is in imminent danger, it doesn't say, oh, you can pull a gun and shoot the person. You can fight back with the same force that the person is using against you, but not necessarily extreme force, unless life or limb are at stake. If I am being attacked by a male who is substantially stronger than I am, I, as a female, can use enough force to rebut what I'm receiving and defend myself. But then is where we enter the gray area of, is deadly force sufficient for a defense of self? How to prove self-defense in court? Well, you have to look to see what evidence is available. If there are audios, videos available, because maybe this happened in a public place and there's surveillance cameras, well, you would use that. If not, then it becomes a battle of credibility. And who does the jury believe? Do they believe the victim and their account of the incident? Or do they believe the defendant and their account? Obviously, it is a 50-50 chance of who the jury is going to believe. So any character qualifications that would make one party more credible than the other, well, that's usually something that we would use in trial. If a person decides to take a case like this to trial where their defense is self-defense, we look into the history of the person, whether they've made allegations of harm to that they were victims of harm in previous cases, the circumstances of those cases. Because if we can establish a pattern of actions on behalf of this person where maybe they are the aggressor rather than the victim, then we can use that evidence to establish that it's more likely than not that because they've acted this way in the past, that this time they are acting in accordance to their path. How important is a witness in a self-defense claim? I think as in any claim or any defense, a witness can always corroborate rather than having the battle of credibilities between the defendant and the purported victim. So whenever there are witnesses, and especially if they're exculpatory witnesses where they can establish that the defendant, one, did not act in the way that the purported victim is saying, or two, did act but was as a defense mechanism, then that plays highly into the results of a criminal trial. So what is the difference between aggravated assault and simple assault? A simple assault can be, like I said, a straight quarrel with someone and maybe some punches are thrown, but nothing egregious. A more severe case would be, for example, when there are breaking of limbs, loss of consciousness is something that is really taken into account, whether the person had to be hospitalized and the extent of the hospitalization, the length of the hospitalization. All of those factors are weighed in to determine whether it was a simple assault or an aggravated assault. So if you have been charged with assault and you believe that it was done in self-defense, by all means, please call Confianza Legal for a free consultation.